Hello. In this video we're going to be looking at the real issue of why it is that I can go into a court down the road in the UK and have EU law applied to my problems. And this is really the question of the authority, the bite of EU law, and why it is that EU law, when push comes to shove, is more important, or rather has precedent and primacy over national law. I have, when making these videos, tried to keep case law and academics to a minimum, but it's really quite unavoidable in this story to have a very large focus on case law. And indeed, when we think about why EU law has power, the story is more about law than it is about politics. And it's crucial to remember at the outset that the power or authority of EU law is distinct and separate from its legitimacy. It can be totally illegitimate, but it can still have punch and power. And so we really start our story with the case of Van Gendenloos, and this is a case concerning tariffs. The real takeaway point from Van Gendenloos is that the ECJ says any court in a member state can send a case up to the ECJ to get the ECJ's opinion on that case. For example, we go to the High Court in England, which is a relatively low court. It doesn't matter that they're a lower court than, for example, the House of Lords or Supreme Court, but they are able to send cases to the ECJ for their opinion on EU law. And the reason why this is so important is because it means that if I, as a litigant or somebody who wants to access EU law, need to have that applied to my case, I don't need to go all the way up to the Supreme Court in order for me to be able to access the ECJ. And that is really the starting point of our story. The real explosion, we might say, comes from the case of Costa. Now, the real point from Costa is that where EU law says something is black and the law of a member state says that it is white, the outcome is that it is black. EU law wins. EU law takes primacy. And the reason for this is alluded to in Costa, or at least this is the reason they give. And the reason they give is that EU law is not simply another form of international law. They explain this by saying, one, it has its own separate institutions, so for example the ECJ, but lots of systems of international law have their own courts. The real points are as follows. One point is that the strength and power of EU law comes from national parliaments. So the creation of the European Union can be described as national parliaments parcelling up a group of powers and giving them to the EU. So what the EU are saying, or what the ECJ is saying in Costa, is that we're not just another type of international law that you can throw away when it pleases you. We have our own power and authority because you at a national level have given it to us. The second point, and this is really important when we consider the idea of democracy as meaning something other than voting. The point is that the European Union takes some of its idea of democracy as meaning the ability to give rights to citizens. For example, if the EU gives you a right to trade without tariffs, this is a right you can enforce against your government. And so what they might say is, alright, let's throw our hands up and say, we're not the most democratic in terms of voting, but the real democracy is that we can give individuals the power to go up against their governments and enforce rights against their governments. And the only way we can do this is if we have primacy of EU law. We can't simply have it so a member state can write EU law out of power. But it's also important to consider another motivation for this. And this is that the EU is, whether we like it or not, really focused on economics. And when we consider that member states are effectively, in a capitalist economy, competing against one another, it is not the case that we can have one member state applying health and safety laws and another not, because one of them will have a competitive advantage and the other will not. The only way for these laws to have effect and for them to be universally enforced is to make sure they're universally enforced, and this is done by saying national courts must disapply conflicting national law when it clashes with EU law. And finally, to wrap up this trifecta of cases, we have the case of Simmenthal. And this really just follows on naturally from Costa. The question here is, can any court in a member state disapply national law? For example, going back to our case of the High Court, is it the case that the High Court, again, are not especially high, not an especially senior court or powerful court in the UK, are they able to disapply national law in the same way that the UK Supreme Court is? So effectively, if I want national law to be disapplied, do I have to go all the way up to the Supreme Court to do it, or can the county court, the very lowest courts, can they do it? And the answer from the ECJ is, of course they can. In fact, they need to. And again, this is all about the idea of ensuring that citizens have access to the EU. But, okay, that's the whole democratic argument. This is the argument coming from the ECJ, that they're really trying to do this for citizens. But if we're a bit more cynical, we also need to consider the fact that if you ensure that county courts, the lowest courts in each member state, can disapply national law, you make it very easy for individuals to effectively enforce EU law. And the way this happens is, if you make it so that litigants, people like you and me, have a dispute, and they can use these disputes to enact EU law, we have it so that this legal regime is being used in national courts all of the time, and this is how laws have power. They become used over and over again, and they're used often, and they're not only used when cases very rarely go up to the Supreme Court. So this is the whole idea of making EU law work. So I've painted this picture of what the relationship is between the EU and national legal systems. However, this hasn't just been taken for granted. Indeed, we do have some cases of rebellion, especially from constitutional courts, so the very highest courts in member states. And I would seek to illustrate this with two examples. The first is the couple of cases known as Solange. So Solange in German means so long as. And the crux of these cases is the idea is there might be a clash between the German constitution, so the highest law in Germany, and EU law. And the question is, effectively, when there is a clash between these two sources of law, will the German Constitutional Court, because this is a German Constitutional Court case, will they roll over and let EU law be applied? And they say it depends. It depends fundamentally on whether or not, they say, the EU provides effective protection of rights. They say so long as the EU provides this protection of rights, we will roll over. We will apply EU law over German constitutional law. So does it provide effective protection? In both of the Solange cases, they say yes, it does. So we'll roll over if push comes to shove. Okay. So we see that there is sort of a confrontation. Germany says, and in both these cases it is Germany. Germany says we won't we won't unconditionally give EU law primacy and supremacy. There is a condition, but at the moment we will. And this is important. This is an important distinction to make from unreserved acceptance of primacy. And then coming to the OMT case. Now, OMT stands for outright monetary transactions. It's to do with a system of buying bonds that was suggested to help out during the Euro crisis. We don't need to worry too much about it, but effectively, the German Constitutional Court says that this regime, this system, OMT, is ultra vires. It's the EU going beyond its power, and that it's not allowed. They also say, as another point, that OMT it interferes with the German right to vote, and this is the fundamental right. This is really the big right in the German constitution. And so this is such an important case because it's the first time that the German Constitutional Court ever asked the ECJ for advice on an issue. So they say, Germany says, we think there's a problem. They send it off to the ECJ. The ECJ says, there's no problem. Then it goes back to Germany, and Germany kind of say, well, all right, we're going to keep an eye on this. We don't totally accept what you're saying. We're going to keep an eye on OMT and see if it really does stray ultra vires beyond powers. And if it does stray beyond powers, we might do something. But it's been 4 years and nothing was done about it. But this really does raise the question of when a constitution of a member state clashes with the EU, firstly, who does win, and secondly, who should win. Because this is the fundamental identity of a member state. And this is really what gets academics excited. I'm very wary of using nerdy terms to describe these things, but the idea of constitutional pluralism is one such theory about how we resolve these conflicts. And constitutional pluralism is the idea that both member states and the EU are right. So, where Germany's constitution says that something is black and the EU says something is white, they are both correct. And then the question becomes, well, all right, we have a problem. Is it black or is it white? And so we come to the answer of whether it's black or white based on politics. So both sets of systems are legally correct, and what actually happens will be decided by politics. And so that's one idea of how we deal with this conflict. But there's another idea as well, and it comes from really a focus on equality between member states. And so some academics would say that, well, actually, we need there to be absolute primacy, absolute supremacy of EU law all of the time. And this is simply because not all member states are equally powerful. It's not a coincidence that it's the German Constitutional Court that throws its toys out of the pram. This is because Germany is a very strong country in the EU. So while it is the case that Germany might be able to throw their hand up and say, we're not happy with this, it is not the case that every member state in the EU is able to do this. And actually the only way to make sure that they are all equal is to make sure that EU law applies equally to all of them. So this is just another way of looking at how we deal with this problem. The real the gut reaction when we look at this history of the creation of the EU legal order is, well, what about national law? What about national courts? What about these hierarchies that we've made? We've made it so that the High Court leads up to the Court of Appeal, and that leads up to the Supreme Court. We have these hierarchies for a reason, and the EU comes and effectively trods all over them. The question also arises, well, what about national law? I've voted for a certain government, and they have enacted these laws. And this government has a very high degree of democratic legitimacy. Meanwhile, the EU, which can be argued to have a democratic deficit, creates these laws. They're created by totally unelected experts, and these laws are taking primacy over our national laws. And so this is really a crucial, fundamental tension that exists within the EU as a legal order with regards to its relationship with member states. And I would encourage you to think about what we should do when these two legal systems collide. If you like the video, please like it. I'll upload this as a picture and some notes in the description, and I hope to see you again next time.